Hi, this is the first episode of a new podcast here at Collier Bristow called Boardroom Conversations. This is going to be a podcast where we talk about the role and responsibilities of company directors, what that looks like, what sort of things directors should be bearing in mind with their day-to-day responsibilities. I'm Helen. I'm an associate in the corporate team at Collier Bristow, and today I'm joined by Ragavan. Perhaps you'd like to introduce yourself.
Hi, I'm Ragavan. I'm a partner in the corporate team here at Collier Bristow. Also chair the private equity audience group.
Brilliant. Well, thanks very much for joining today. Today, we're actually going to be talking about sort of key considerations for directors when it comes to decision making for a company. What sits with the board, what sits with shareholders, and what they should be thinking about along those lines. Ragavan, perhaps you could talk to us a bit about what the difference actually is between a director and a shareholder.
In a nutshell, I think the difference between a director and a shareholder, the directors are responsible for the day-to-day management of the business. So the directors, collectively known as the board, I would conceptualize them as the mind and will of the company. They're the people who are charged with making sure, bills get paid, contracts are entered into, employees are employed on the correct terms. Their role is running the company, essentially. And that's
pretty important stuff then.
Yeah. Yeah, exactly. Important stuff, which is also, they have duties which are codified in the Companies Act 2006. Prior to that act, their duties were kind of legislated for in various pieces of kind of common law. So I think the government at the time took the decision that in order to increase the caliber of directors, it would be best if directors knew what their duties were in one place, and therefore they drew together all their duties into this one piece of significant legislation called the Companies Act 2006.
Yeah,
but
just to kind of find it all in the same place.
Exactly, because it's much easier for directors to discharge their duties if they're not looking to various sources.
If they're not spending all their time reading the legislation rather than actually following it.
You don't even, exactly. You want to be following it. It wants to be clear, but obviously, that's why you have you and I, Helen, to walk through directors any points where anything isn't clear. They don't have clarity on what they're supposed to do. I've rambled on directors now. When just to go back to your question as well, what is the difference between a director and a shareholder? Well, I guess so. We talked about directors as being the directing mind and will of the company. The shareholders are essentially the owners of the company. So shareholders will have shares, which are essentially a bundle of rights, both economic and potentially in terms of income rights and capital rights. So you may be familiar with the concept of dividends, which are income rights, for example. And allied with that, they also have voting rights. So it's a mix of both kind of economic and voting control rights. But it's slightly distinct from the directors' controlling rights in terms of the directing mind and will of the company, insofar as I've alluded to, directors have all these duties they need to adhere to, where shareholders have less or potentially less restrictions on the way they exercise any of their rights of control.
That makes sense. And I suppose where it can get a little bit blurred is that actually you can have shareholders who also act as the directors of the company, and then it's just incumbent on them and of course the company generally to ensure that they're thinking about which capacity are they acting in at any given time, which hat are they wearing, their director hat or their shareholder hat, as it were.
Yeah, and that's a great point, because often with smaller businesses, there can be, as you say, a commonality between the shareholders and directors. But it's very important that whenever they're making a decision, they're understanding it and they're looking through the whole context of that decision through the lens of, am I making this decision as a director or a shareholder? Because there'll be very different levels of responsibility and onus depending on which hat they're wearing. And also, I must admit, I always loved, everyone always refers to it as different hats. So just imagining a row of people with fancy hats, which they can just swap in and swap out if they want. But it's incredibly important. Yeah, exactly. That's what directors and shareholders do all day, just swap their hats. But it's incredibly important that people have clarity about what role they're discharging and what point in time they're discharging it, because I've seen a lot of people get into trouble because they're not thinking of themselves as directors of the company who are acting for the benefit of the shareholders as a whole, but they're just making decisions based on their own personal shareholdings. And as you can imagine, if you're doing that, but you are a director as well as a shareholder, you can get yourself into a lot of bother, particularly with other shareholders who may not agree with the direction of travel that you're taking them on.
So with that in mind, then, what decisions do rightfully sort of sit at board level with the directors, and what should be referred over to the shareholders?
The decisions that should be referred to shareholders, unfortunately, many of them are laid out in statute. There's key business decisions of the company which are legislated for in the Companies Act 2006, and they're often decisions of major substance. So altering the articles of association, which I'm sure we'll come back to later. So altering the constitution of the company, or maybe changing the company's name, reducing the share capital of the company. These are all decisions which are potentially taken by shareholders, and they can be taken by shareholders convening a meeting or having a meeting convened, or they could be taken by a written resolution procedure where shareholders sign their consent to a certain course of action. And when shareholders are making decisions, it's important to note that depending on the importance of the decision, you may need a different threshold of shareholders to be on board. So if the decision is conceptually that important, you'd have to maybe pass an ordinary resolution, which would be a simple majority of the voting rights, a simple majority of the shareholders voting in favour of an action. However, more significant decisions, as I say, altering the company's constitution, may involve the passing of a special resolution where we have a 75% threshold. So the greater threshold obviously is reflective of the greater importance of the decision being made and the need for more people greater than the majority of the shareholders to be on board with that decision.
That makes sense. I suppose as well, it's worth noting that it is open to shareholders to choose to reserve some decisions that might have otherwise sat more naturally at board level. They can choose to reserve some of those for themselves, normally in the shareholders agreement, for whatever reason that might be, if they want sort of more oversight, or there's a minority shareholder that perhaps wants a little bit more control over things than they might otherwise have had.
I think that's a great point. I think, obviously, as I've mentioned, we have this statutory regime within which companies operate, but that can always be enhanced by either entering into separate contractual relations. I think you mentioned a shareholders agreement, which is a relationship between the shareholders to govern the running of the company, which can often supplement or enhance the articles, which are the constitution file that Companies House. And often when you're thinking about constitution, and I'm sure we can get into this, and I'm sure there's going to be another episode where we'll just speak specifically about these kind of spoiler alert. If you incorporate a company, often use what we term the model articles, but they may be fit for smaller companies. But if shareholders and directors want to more kind of appropriately delineate or enhance the rights given by the statutory regime, we can often produce bespoke articles of association that deal with specific issues which don't habitually come up with smaller companies, but come up when you have more than one shareholder, shall we say, or you have a clear distinction between management and shareholders. So often for companies which have a commonality between directors and shareholders, they can get away with more simple constitutions. But the more you have a separation between interests between shareholders and directors and the parties involved in the running of the company, the more important it may be to consider whether you need to move away from the kind of standard model articles and put in some bespoke provisions.
That's helpful, thank you. And then I suppose, just because we've talked about what matters might be referred to the shareholders, everything else that's going to sit with the directors, or obviously in a larger company potentially be delegated down. But so that's what going to cover things like filing of annual accounts and tax returns and the like.
Yeah, exactly. They're kind of responsible for the day-to-day operations. At one level, it is making sure that your Companies House filings are up to date and your accounts are filed. The buck stops with the directors to get that in and make sure there aren't fines. It's just really everything to do with the company.
Yeah.
So any substantive decisions that a company takes are taken by the directors. And it's important that when they are making decisions, they pay attention to their duties. They briefly alluded to them, but it may be worthwhile having just a quick canter through some of the...
It's good you've mentioned that, because we do actually have another podcast on the duties of directors. We can point people that way as a casual...
Well, so that's another spoiler alert. Going off these, you've already legislated. But so I mean, ultimately, directors need to, whilst the company is solvent, need to act in the interest of the shareholders. So it's all about directors acting in the best interests of the company, avoiding conflicts of interest, making sure that they're maximizing the returns for the shareholders. But also the Companies Act introduced this idea of stakeholder engagement. So it's important when directors make decisions as well that they consider the longer term impact of their decision making. So, whether that be environmental or social, it's important that we have and directors have a holistic kind of approach to the kind of business plans that they have. Although I must admit that sometimes down to the minutes. So crafting good minutes to ensure that you accurately recorded why you've made a decision can be very protective of directors. And I'd always advise directors do minute their decision making, if only just to build the correct narrative and story so that people understand why they did what they did and make sure that it aligns back to the discharge of their duties. Just dialing into a specific point, I guess it's worthwhile mentioning this concept of quorum, making sure that whenever directors are discharging their duties, they're also looking at the company's constitution, as we kind of touched on, to make sure that board meetings are quorate. And by that, I mean, often, you'll have articles which legislate that you need to have 2 directors in order for a meeting to be quorate, and therefore business cannot be conducted, decisions cannot be made without there being at least 2 directors present.
No, and that is important. It can be really easy for directors to get caught out if they've not given that proper thought. And particularly just thinking back to what you mentioned earlier about the directors being subject to various duties, if they're conflicted in those duties in any way, they have an interest in the matter that's being discussed, whatever it might be, then of course they might not be able to participate in the quorum, depending on what the articles say. And then you suddenly find out you've accidentally taken a decision that you weren't authorised to take.
Exactly so.
Which is always best avoided.
It's always best. If you can avoid it, you should avoid it.
Yeah, that would be our view as a starting point, shall we say.
And also structuring, that's a really good way of keeping decision making rigorous if you you're producing board minutes, because often when you're opening board minutes, one of the first things that you direct your mind to is whether there's a quorum and who's conflicted. And I think it's a good way of making sure that when you're having board meetings, you are ticking the right boxes if you have the formalities of board minutes. I know often for smaller companies, they don't do that, but I would always recommend making sure that you do go through the basics when you're opening a board meeting and make sure that the right people are there in order to fulfill the business that you're planning to fulfill. Just to touch on that, I think it's great that, we moved on from kind of my time when often board meetings were held in person. And now, you have flexibility to hold board meetings, by telephone, over videos where people in many different parts of the world. But make sure you always just check your articles to make sure that kind of meetings are allowed, because it's really always important to understand that driving both decision making at board and shareholder level is the company's constitution. So make sure that you know what boxes you need to be ticking in order to have a quorate board meeting, a validly convened board meeting, validly convened shareholders meetings, what you can and can't do. It's really important that that if something is not working for you, you make sure you amend the articles or the shareholders agreement to make sure it does work and is fit for purpose.
Well, that actually ties in really nicely to what we're going to be talking about next time. So thank you for that. Next time we will actually be talking about, well, this, you're going to be there, but for the benefit of others, we're going to be talking about the role of articles of association and shareholders agreements in the governance of a company and what it's worthwhile directors knowing about that. So if that sounds interesting, then do come back and listen to that. Thanks very much for listening, and I hope you'll join us again next time.
Great. Thank you so much.